Jingle bells, jingle all the way. Hey,
Alright, but before you answer this question, I want to ever stop and think about your little pretty girl, your girlfriend, your chick. They smell and they spin. Dude, you have no appreciation of the finer sex.
Because she was thrown from the car. Hit the side of the house.
Very large blood splatter there.
Dented the siding. Smell that alcohol?
Yeah, very strong smell of alcohol.
Christmas Eve.
Just saying.
Have you been drinking? What is wrong with you? Wait a minute, he ran into my house. Sir, calm down.
Relax, sir.
Yeah. Oh, man.
Where are you hurting at right now? How's Susan?
Date of birth is February the 10th of 1970.
17.
You hurting anywhere right now?
That.
Left collarbone.
Anywhere else?
Right there, that.
Left ribs, left side.
Yes, sir.
Yeah, you get knocked out?
Sticking out. Not quite.
Not quite. Where were you at in the car?
Back seat.
Back seat? Let's get your lungs down real quick, okay?
Fractured skull also.
Okay.
I bet she hit the house head first.
Okay. Massive head trauma.
That was a hell of a crash, huh?
You remember what happened?
We were drinking a little bit. Then crashed.
Got a body bag?
Yes.
A bag to put her jewelry in. If you want to make a note on her jewelry.
Okay.
2 bracelets, wedding band,
Okay.
2 earrings. I don't see any sign that she was wearing a seatbelt.
Okay.
So were you driving the car?
Yeah, I was driving.
Okay, we're gonna put you on a board and take you to the hospital.
Zach, do you understand the rights I've just read to you?
Yeah. How's Susan?
I don't know, Zach.
What about Mark?
I don't know. Zach, were you driving the car?
No.
Who was driving the car, Zach?
Mark was driving.
Mark was driving that car?
Yeah.
Nurse, I'm going to need you to draw some blood for me. He's been drinking. Yes, Zach, I'm going to need you to sign some paperwork for me. I'm going to need to draw blood.
I'm not signing anything.
What I know at this point, the events leading up to it, they were at a club called Alley Cats, located in Marion, just a couple miles away. They'd been there for about an hour and a half, 2 hours, consuming alcohol. Once they left Alley Cats, they went down Highway 76, went on to Melvin School Road, and at that time, that's when they lost control, flipped end over end, and that's when the accident occurred. Well, after I arrived at the crash scene and the accident scene, my first thing to do was go ahead and collect evidence. There were other troopers that were there with me. Once I got to the hospital, there were some of their friends there, and that's where my investigation really started taking off.
We were drinking at Susan's house, then we stopped by Smoker's Express before going over to Alley Cats. Mark was driving.
Did you see Zach leave Alley Cats?
We went into the parking lot together. Zach got into the driver's seat of a white BMW. Susan got into the passenger seat, and Mark into the back seat. They left, and I went back to Alley Cats.
Did you consume any alcohol while you were there?
Yes, sir. We all had some.
Did you see Zach leave Alley Cats?
I saw Zach get in the driver's seat of the white BMW. Mark was in the back seat. I know I saw Zach drive out of the parking lot that night because I hugged Susan while she was still in the passenger seat.
An investigator will go to a magistrate with the evidence that he has in order to get a warrant signed. He relays to the magistrate his probable cause, and the magistrate determines whether or not there is enough to sign a warrant. And once that warrant is signed, then the officer can go and arrest the defendant. Once the warrant is served on the defendant, then the defendant is entitled to a bond hearing, and the magistrate will conduct that bond as long as the crime does not carry life or death.
You understand what was just said?
Yes.
If you fail to appear in court as required, there will be additional charges and or a fine of imprisonment up to $5,000. If you're convicted of these charges, you may be sentenced to a mandatory fine of not less than $10,000, no more than $25,000, and mandatory imprisonment of not less than 1 year, no more than 25 years. Do you understand what I've just said?
Yes.
Because you have no previous convictions and you're still in high school and living at home with your mother, I will agree to a bond of $5,000 for each count of the offenses. You're not to leave the state without permission of the solicitor, and you have an 11 p.m. curfew. Further, you're not to breach the peace in any way, and you'd be of good behavior towards everyone. Do you understand what I've just said?
Yes.
The grand jury comes in once the magistrate binds over the case at the preliminary hearing to General Sessions. Then the case is basically transmitted to the solicitor's office.
It was a true bill of the indictment by the grand jury in this case, and the 18 grand jurors found that there was enough evidence for the state to continue to prosecute the charge and for the defendant to answer to the charge.
Once we investigate the case and send it to the grand jury, there are basically three options. The case can either be dismissed, the defendant can plead guilty, or the defendant can ask for a jury trial.
Well, in this particular charge, Zach was facing felony DUI charges. At that point in time, he's probably working with his lawyer, preparing his defense, getting ready for trial. There's a discovery process where the evidence that the state has, a certain amount of that evidence is discoverable to the defense that they ask for. It's not trial by ambush. We let them know what they're facing, what evidence is against them, and they prepare to defend that case. Also, a part of the process is the possible negotiations if a plea is to be entered of guilt as opposed to going to a trial before a jury.
The defense had established two witnesses that stated that Zach was not the driver of the vehicle when it left a station, filling station near the nightclub where they had been.
We went and looked at the time frame of when they could have possibly seen them, and we looked at their testimony in light of several other witnesses' testimony as to the time frame, who was following the car, who saw the car leave, and also what employees saw at the Smokers Express. And there were a couple of individuals that probably saw Mark drive the car, but it was before they went to the club.
We took the boots from the defendant Zach along with the brake pedal off of the vehicle and sent them to SLED for analysis.
Our mission is to see that a crime, a serious, especially serious crime in the most rural area of the state gets just as much attention and as much police resources as in one of the larger areas of the state.
What I got was a pair of boots, and I got a brake pad. And the request was to see if there was any marks on the bottom of the boot that might match the brake pad, and to look at the brake pad to see if there was any marks on the bottom of it that may match back to the outsole of the boot, or the bottom part of the boot. First thing that was noted and was obvious when the items were submitted was this curve mark that run along the inside edge of the heel all the way across. That was compared to the bottom of the brake pad, or the end piece. Notice the curvature and the curvature mark there. Also, what was observed was a little cut mark on the edge of the impression, which was later found up in the brake pad itself. Following the edge line that was on the bottom of the boot, a second indented area was found in the impression and was again correlated back to an area on the brake pad itself.
Through the use of DNA, fingerprint analysis, and other very specialized sciences, crimes that would never be solved before are now being solved, in some cases, very quickly.
I felt like we had a very strong case because of the, number one, the evidence that we had gotten back from the SLED lab, and also the witnesses and the timeline that we had established during the investigation of this case.
Once the defendant determines that he wants a jury trial, 12 jurors are selected once a court date is set, evidence is presented, the case is heard, and then the jury deliberates and determines whether or not the defendant is guilty.
Zach, the day before we were going to trial, pled to reckless homicide, which carried up to 10 years in prison. He did that rather than go to trial and face felony DUI, which carried from 1 to 25 years.
If the defendant decides that he wants to plead guilty, a court date is set. The solicitor relays the facts of the case to the judge, and the judge then sentences the defendant.
This is a 2-count indictment, Your Honor. Felony driving under the influence causing death, felony driving under the influence causing great bodily injury. Now, he's pleading to a lesser charge of reckless homicide on the first count. And at the request of the victims, the second count is being dropped.
And he understands, even though he's pleading in this fashion, that it's still a conviction nonetheless?
He understands that.
Mr. Altman, would you please stand and raise your right hand? Do you solemnly swear that the answers you will give this court are the truth?
Yes, sir.
You can put your hand down. How old are you?
18.
How far did you go in school?
11th grade.
Do you want to exercise your constitutional right and plead not guilty in this case and have a jury trial, or do you want to give up that right and plead guilty to this charge?
I give up my right.
How do you want to plead?
Guilty.
Do you understand that even though you are pleading to a lesser charge, it'll still be a conviction, and that the state could prove you guilty of a greater offense, that being felony DUI?
Yes, sir.
I find that there's a substantial factual basis for this charge. I think this is an appropriate plea. I'll accept this plea.
Once he enters a guilty plea, the sentencing is solely up to the judge.
The judge determines how to sentence an individual by listening to the solicitor's facts, by listening to victims, by listening to witnesses, and by listening to the defense.
Your Honor, on behalf of the state and on behalf of the family, we would ask that you strongly consider giving Mr. Altman the maximum sentence for reckless homicide, which is 10 years. I know you have the ability to suspend some of it or all of it. And I would strongly ask, Your Honor, that you not suspend all of it, and that you give him the full 5 years probation based on the facts in this case. Further, we would ask that a condition of that probation be alcohol and substance abuse treatment, counseling, intensive if needed. He's a young man. He was 17 at the time. Should not have been drinking. Was underage drinking. Certainly should not have been driving. And his driver's license was suspended at the time. Now, we believe he needs some help, as well as punishment. He took it upon himself to get in that vehicle and drive it in the state that he was in, and he should be held accountable. Nothing will bring Susan back, nor fill the loss that these victims have suffered.
Your Honor, let me say that I have learned in the last week especially in a striking way that Zach here is scared to death. He is scared to death. He's a child. He doesn't think he can survive in jail. He's heard stories from those who are close to him, and he is worried. I would say to you that this is a case in which the court ought to consider probation, and I will tell you why. Because those people who were in the car with him shared the blame along with him. Now, that doesn't excuse what he did, but let's accept it for what it is. He was 17 years old. He was drinking and apparently driving. He shouldn't have done that. He didn't intend to commit a crime. But he is going to suffer tremendous punishment without ever serving a day in jail. He has already lived this past year in great fear of what was to come. He's going to have a felony record. His driver's license will be gone for 5 years. He is a young man, and he has a chance to do better. It was a precious life that was lost that night, but putting Zach in jail won't change that. So we ask for grace. We ask for mercy, Your Honor.
I'd just like to say I never meant to hurt a hair on Susan's head. She had a place right here. I'm sorry. I wanted to apologize. I didn't mean to hurt her. Mark, you know, I didn't mean to hurt you either. Didn't mean for any of this to happen. All that said, that ain't gonna bring her back. I didn't mean it.
Your Honor, Mr. Martin said that Zach would have a chance to do better. Unfortunately, Susan won't have the chance to do better, or to do anything. And as far as Mercy is concerned, he has been blessed with mercy when they didn't carry his broken body away from that wreck. He's alive, here today. His mama can hug him. Susan's family cannot hug her.
Your Honor, I'm representing the victim's husband. Your Honor, this young man has expressed no remorse for what he did. And quite frankly, I'm appalled that he won't even admit to anything. Now, I know when you flip a car 3 or 4 times and you get ejected from that car, it could quite possibly scramble your brain so you don't remember everything that happened. But he told the EMS driver that he was the one driving the car. He still will not accept responsibility for his actions. Today, in this courtroom, first time I've heard him apologize to anybody. Your Honor, I am asking you to give him substantial jail time and probation, which requires him to undergo drug and alcohol testing.
Your Honor, how do you tell a 4-year-old that her mama's gone? They say Zach's young, but my little girl's 4 years old, and she don't have a mama. Yeah. Oh, yeah, I'm still here, but I don't know for how long. They say I'm in remission. Yeah. Yeah, he's young. But he got in that car, and he drove it. He assumed responsibility. So please, just do what you got to do. Thank you.
Okay, thank you, everyone. The sentence on this indictment will be that you are to be confined for a period of 10 years. In addition, I place you on probation for a period of 5 years and provide that while you're on probation, you are to obtain your GED, have substance abuse counseling, and that you submit to random drug and alcohol testing, and that you attend one Mothers Against Drunk Driving Victim Impact Panel meeting each year that you're on probation. Good luck to you, sir.
Whether or not a defendant is found guilty of a felony DUI charge or a reckless homicide charge, the victim's family can also pursue a wrongful death action in civil court, which can be extremely costly.
Zach is doing time for the crime he did commit while driving that car under the influence.
Once a defendant completes his jail time, he will be placed on probation for a period of up to 5 years. This will curtail his freedom tremendously. He will lose his driver's license for an extended period of time. This felony conviction will also affect him for the rest of his life. He will lose the right to vote. He will not be able to apply for scholarship or grant money in order to attend college, and he will not be able to get certain jobs in the future.
It's a horrible thing for someone to do that to themselves. DUIs and felony DUIs is one of the few crimes that doesn't require criminal intent. You don't go out and you intend to get drunk and hurt someone with the vehicle, but you don't have to. You just have to drink and drive.
There's no sense in anyone getting behind the wheel of an automobile if you've been drinking. If you go to a party, you're having fun, there's too many ways to get home or to get where you want to go without getting behind the wheel of an automobile and killing someone or killing yourself.
People don't think, and they don't look to the future, and they don't look for the consequences of their actions. And what can be done to stop it is that we hold people accountable, and that maybe others will learn because of the consequences and dire consequences of what happens to someone else who's crossed the line and drank too much and drove a car and injured someone.